Good afternoon, everyone. This is Evergreen Middle School Unit 5. For the judges, we have 5 participants today, and then they have quite a few guests who've come along to support them as well. So those of you who are not presenting today, please remember to stay muted and keep your cameras off so that we can focus on the presenters today. My name is Mark McCall. I'm your facilitator and timekeeper for this afternoon, and I'll be helping you out tomorrow as well. Your judges will introduce themselves in just a second, and then they'll ask you to introduce yourselves. Just as a couple of reminders for your timing, 4 minutes for your prepared speech today, followed by 8 minutes of questions from the judges, and then they will provide you some feedback at the very end, just so that everybody, since we do have a large group today, so that everybody can see the timings. I'm going to use virtual background. When there's 1 minute left, I'll go green. And then when your time is up after 4 minutes and 8 minutes, I'll turn yellow. And with that, I'm going to mute myself and turn it over to our judges.
Well, congratulations and welcome. You're to be commended for getting here, and your teacher is to be commended for teaching you through these trying times and giving up her weekend for this activity. We're so grateful that you're here. My name is Rebecca Tinder. I am a retired attorney from Charleston, West Virginia, and the West Virginia We the People coordinator. Lindsay?
I'm Lindsay Draper, retired from the juvenile court bench here in Milwaukee County, Wisconsin.
You're muted.
I know. My name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. And I've been with the program for 20 years, so I'm delighted to see all of you here.
And you are?
Hi, my name is Angela Dong, and I'm an 8th grader at Evergreen.
Hello, my name is Elliot Kaiser. I'm also an 8th grader in Evergreen.
Hello, my name is Roller. I am also an 8th grader in Evergreen.
Hi, my name is Misha Singh, and I'm a 7th grader at Evergreen.
Hi, my name is Hongning Wang. I'm an 8th grader at Evergreen. On behalf of Evergreen Middle School Unit 5, I thank you for your time.
Great. All right. We will read the question, and it's question 1. When a choice must be made, it is better to allow those who preach racial hate rather than to be panicked into embarking on a dangerous course of permitting the government to decide what its citizens may say and hear. Do you agree or disagree with Judge Bernard Decker's upholding the rights of Nazis to march in Skokie, Illinois? Why? What limits has the U.S. Supreme Court placed on freedom of expression? What benefit, if any, is there from presentation of ideas that are designed to alarm, antagonize, and offend members of society? What limits on freedom of expression, if any, should be placed on media sites? You may be.
Voltaire once said, "I disapprove of what you say, but I will defend to the death your right to say it." In 1977, the National Socialist Party of America proposed to hold a march spreading white supremacist views in Skokie, Illinois, a town with many Holocaust survivors. An ordinance blocking the march was later overturned. While Nazi views should not be tolerated in our society, we agree with Judge Decker's upholding of the rights of Nazis to march on Skokie, noting that the freedom of speech and assembly is protected under the First Amendment so long as it meets the imminent lawless action test. The Supreme Court has historically upheld First Amendment rights of people with controversial opinions.
In Brandenburg v. Ohio, the Supreme Court sided with a Ku Klux Klan leader convicted of violating an Ohio criminal syndicalism law. The Supreme Court established the imminent lawless action test that only prohibited speech that incite or produce imminent lawless action. In Police Department of the City of Chicago versus Mosley, the Supreme Court overturned an ordinance allowing one type of protest near school grounds, establishing the content neutrality principle, that the First Amendment prohibits restriction of speech based on content. Thus, the Nazis had the right to march on Skokie, protected by the content neutrality principle and the imminent lawless action test. Freedom of expression in social media has been a rising issue after violence such as the January 6th attack on the Capitol, which originated from hate speech on social media.
We argue that restrictions should be placed on social media using the imminent lawless action test. Alanis versus United States was the first case involving the constitutionality of prosecuting potential threats in social media. In 2015, Elanis was convicted for threatening people on Facebook under a law that criminalizes the transmission of threats in interstate commerce. The court ruled that Elanis did not intend to cause injury. This ruling set the standard for how we believe courts should interpret social media posts, through its likelihood to incite or produce imminent lawless action. In Rabb versus St. Paul, the Supreme Court reinforced the fact that the government has no ability to support one side of the argument while limiting the other.
Robert A. Victoria, a juvenile, along with others, assembled a crude cross and burned the cross inside the fenced yards of the Joneses, a Black family. He was arrested and charged under a bias-motivated crime ordinance of St. Paul, Minnesota. The Supreme Court later ruled that the crime ordinance unconstitutionally singled out particular content-based viewpoints.
In this case, and many others, the Supreme Court struck down laws that unfairly discriminated against certain viewpoints based on their content. The U.S. Supreme Court has placed restrictions on the freedom of expression in the past. In Chaplinsky v. New Hampshire, the U.S. Supreme Court ruled against Walter Chaplinsky, a Jehovah's Witness who distributed literature attacking other forms of religion. He used obscenities in his description of the town marshal and was convicted under a law that prohibited offensive speech in public areas. The Supreme Court sided against Chaplinsky, arguing that the First Amendment does not protect fighting words, an application of the imminent lawless action test. Some say that racial hate provokes violence, such as the Christchurch shooting influenced by racist opinions. However, preaching racial hate is preferable to restricting speech.
In Myanmar, activist Aung San Suu Kyi led the nation towards democracy but supported hate against Muslim minorities. However, the military government in Myanmar recently seized power after landslide victories by Suu Kyi, suppressing protests and blocking internet access. In the light of this, we conclude that preaching racial hate is better than permitting the government to control speech. In addition, the presentation of ideas that are designed to alarm, antagonize, and offend members of society allows people to present different opinions. For instance, the Stonewall Uprising presented controversial opinions at the time, but led to increasing recognition and rights for LGBTQ+ people today. George Orwell once said, "If liberty means anything at all, it means the right to tell people what they do not want to hear." We reaffirm that all speech that fits the imminent lawless action test, no matter how controversial, is permitted under the First Amendment.
You mentioned content neutrality more than once in your prepared remarks. What about false speech? Things that are known to be false. Is there a First Amendment protection to me saying there is no such thing as COVID? It's all a hoax.
I believe that your statement that the false facts is theoretically still protected under the First Amendment. In our argument, we stated that the only situation where it is not protected is either under restriction by the Supreme Court, such as obscenity or other things such as child pornography and things like that. But in this case, the imminent lawless action test does not apply here because your statement does not directly inspire others to take imminent lawless action against the community or against other individuals. So even though the false facts are obviously not true, we still do not believe that they should be regulated.
And it doesn't matter if people get harmed because they believe me and then they act in ways that cause other people to get sick or die.
Well, in this case, it would not be protected against by the First Amendment because it directly causes harm and thus it violates the imminent lawless action test.
I would actually disagree with what my partner said because it's not the person's speech, it's what the person decides to do after listening to that speech. And I believe that in this case, it is protected.
So if I were to tell you that I believe times have changed so much since that march in Skokie, that we have a much more heavily armed populace, that we have people who are much more polarized and frankly, much more aggressive and much more likely to act out. And therefore, I believe we need to rethink that decision. Would you agree with me? I mean, I know what the law says. I just think we need to look at it again. Do you agree or disagree?
I would disagree.
You go first.
I would disagree because, well, first of all, you'd have to give me the evidence for that. But also, if you were to just like prosecute people based on their content, which in this case is how radical they are, how non-mainstream they are, that would be violating the content neutrality principle, and they still deserve to have First Amendment rights.
And understand that I'm not talking about prosecuting. I'm saying we're not going to let people march through the Proud Boys are not going to march through inner city Chicago. And the Black Lives Matter people are not going to march through suburban districts because times have changed and people are too sensitive and much more likely to act out. That's what I'm saying, not prosecution. I'm saying not letting them march.
Well, we have stated in our argument that there is benefit to having people hearing opinions that are not that do not necessarily like they don't necessarily agree with. In fact, there was a quote attributed to I believe it was there was a quote attributed to George Orwell, and it says that the right to the right to like to liberty is the right to tell people what they do not want to hear. So even if they don't want to hear this, they should still, it still is the protesters' rights to say this.
Adding on to that, and there's been a history of whenever speech is oppressed, it leads to more people wanting to speak out on that same issue. And if you further oppress the protesters' ability to protest about cases and things like BLM, it will lead to more violence, in my opinion.
And to add on to my colleagues, while we were actually writing our response, I have to admit we were a bit conflicted about the truth of considering your issue. That today, these issues will have changed, and for example, like we mentioned, the Christchurch shooting, they were influenced by ultra right and racist views on social media, but we still believe that the points we stated in our speech, that the controversial opinions of today might become the norms of tomorrow. Like Ruth Bader Ginsburg was famous for her dissents in that area. For example, we said that LGBTQ plus and racial equality were once controversial, and such actions did polarize the nation, in fact, leading to civil war and things like that. But today, we recognize these views as the norm, almost like racial equality. So the controversial opinions of today may be the norms of tomorrow. So we should not limit viewpoint or speech simply based on content.
Okay, thank you.
You're muted.
So you talked about, I appreciate your conversations about Stonewall. Can you talk a little bit more about the LGBTQ changes that have made and what you think can be, I'm sorry, I'm getting a little tired here, so is everybody else. Why don't we just ask, how would you define hate speech?
Well, I would personally define it as speech that violates the imminent lawless action test, as we've talked about in our like argument. But the Supreme Court has also said fighting words in like, for example, Chemplinsky v. New Hampshire. Walter Chemplinsky, he used fighting words in his description of the town marshal. He used multiple obscenities, and he said things that were very controversial and actually like argued for fighting and all. And that I would personally think is hate speech.
I actually like to extend my colleague's definition of hate speech. I think it is just speech that particularly attacks or targets a certain group of people. For example, racial hate. It may just be against a certain race of people. Hate speech isn't just about inspiring people to take eminent lawless action. I think personally should just be discriminatory speech against others that cast them in a lower light. I think in general we should just consider that to be hate speech. But I'm going to go on a bit of a tangent that wasn't asked, but I still think that hate speech should be still allowed, even though it has many negative views. It's better than at least the government restricting what people can say.
Does freedom of expression contribute to good government? Explain your answer.
I think freedom of expression allows the people to voice their opinions, and it pushes for change in the government. And if the freedom of expression is taken away, then people do not have their right to express their views.
Very well done. I enjoyed your presentation, and you all are to be commended. And going last at the end of a long day, that's a difficult thing to do. I enjoyed your beginning, starting with the Voltaire quote, and then going through some cases and explaining why they were relevant to us in your 4-minute prepared remarks. I particularly like the discussion about Myanmar, which we haven't heard today, and your Orwell quote. So you bookended your quotes in your 4-minute prepared remarks in an effective way. During our question and answer, I think you were clearly responding to our questions with the struggle of where is that balance, where do we go, and how do we analyze each one of these. I liked that when you got an example, you said, well, first I would need evidence. And I appreciated that. You're not going to just take that question at its face value. You want to look into it a little bit first. And I think that is definitely an exhibition of your learning in this class, that we just don't accept everything we hear. We must look further. And I think that's excellent. You were able to communicate to us different opinions a little bit in the Q&A as well, which is always good. It shows that you're looking at both sides, which is always helpful to know and understand both sides of any argument so that you have considered them. We need to hear each other first and then form our opinions and support them with evidence. And you did a very good job. You are to be commended. Thank you so much. Lindsay?
So I very much enjoyed your presentation. I really wanted to talk to you. It was not as critical a point as some other stuff. There was a comment, Nazi views should not be tolerated. And then I wanted to say, well, wait a minute. But then you went on to explain, but you can't not let them say what they had to say. And I wanted to get back to how do we address that if we're not going to tolerate them? You know, people can say what they want to say. It was an interesting fine point and distinction that I caught you making there. But on the important things, the cases that you cited, the position that you espoused, and then that you defended, you did just a very admirable job. I enjoyed your presentation, and you are rightly proud of yourselves. And the teacher, and my request is please don't forget, because next week is Teacher Appreciation Week. And be sure that you all let the teacher know how much you appreciate the work that went into making sure you all could come off as well as you just did. Thanks.
Great job. That was a really lovely job. And I agree with my colleagues, starting out with a Voltaire quote and the Mosley case, that content neutrality was very helpful and interesting point. Bringing up the January 6th insurrection was well done and pertinent at the time. Myanmar was a really nice point to have brought up as well. I'm just really pleased to see all your faces here and to know that you probably know as much about the Constitution as anybody in my law school class knew. So I hope that you will use the experience you've had here not just to be excellent citizens and go vote every opportunity you have and read the paper and tell your friends what you think, but that you also might consider using this experience in the future and consider representing the rest of us. We certainly can use lawyers and judges who know what they're talking about, but also especially representatives, locally, state, and federal representatives who can take care of us, who know what the government is supposed to be about. There are not that many people who do. So it would be very helpful to have you there, and I would sleep a whole lot more easily in my nursing home knowing that you all are in charge down the road. So I hope you're inspired by this experience, because we certainly are, and you inspire us. Thank you. It was a great job.
Thank you, team. Thank you, Ms. Kessler, for all your hard work. We appreciate it. And we will see